We'll now take up the case of Covington versus the state of Florida. Counsel.
Good morning, and may it please the court. My name is Courtney Hackett, and along with co-counsel, I represent Edward Covington, one of the most profoundly mentally ill people on death row. This case comes before this court on appeal from the circuit court's denial of Mr. Covington's post-conviction motion after an evidentiary hearing was held. Mr. Covington's convictions and death sentences should be vacated because the capital conduct was committed by a man who struggled with serious mental illness his entire life, the full extent of which was neither presented to nor understood by the trial court due to trial counsel's ineffectiveness. We understand
Counsel, I understand that Mr. Covington's got some serious problems, but doesn't the record reflect that most of his problems were the result of abuse of cocaine and alcohol, and that he would engage in behaviors, basically out of control sort of behaviors that were triggered by that abuse, and that he knew it, and that he did it anyway?
Your Honor, that is part of the issue with trial counsel's ineffectiveness in presenting and developing the mitigation. The sentencer's order reflects a completely inaccurate understanding of Mr. Covington's use of cocaine and alcohol. The sentencer characterizes it as voluntary, and while yes, Mr. Covington did ingest those substances, quote unquote, knowing it would cause rage, his alcohol and substance abuse were the product of his mental illness, not an entirely volitional choice.
Help us understand the rule you're asking us to adopt then when someone ingests an illegal substance and it has a mood altering or behavior altering effect, and how you propose this court deal with, the voluntary choice of an individual. You said quote unquote voluntary. Help me remove the scare quotes. When are we supposed to say, okay, this wasn't a voluntary act?
Your Honor, had this properly been presented to the sentencer as a product of his mental illness, as polysubstance abuse that was driven by his mental illness rather than an entirely volitional choice, it would have been better understood by the sentencer rather than being used as a non-statutory aggravator to demote the mental health mitigators. And so, Your Honors, what we're asking for is that Mr. Covington's death sentences be vacated because the sentencer's order reflected a misunderstanding of that alcohol and substance abuse. Had Mr. Covington not pled guilty and waived jury, had he not pled guilty, he would have presented an insanity defense, which would not have been negated by the alcohol and cocaine use. There were numerous times throughout his life where he was stabilized when he was receiving the proper medications. However, after failed attempts at getting those medications and getting stabilized, he engaged in self-medication with those substances in an effort to sort of stabilize his own mind when he wasn't receiving the proper mood stabilizers.
Could you elaborate, though? I mean, given what the record shows about what counsel knew from the various experts they had consulted with, I think it was up to 17 possibly, or at least 7 or something, only one of whom would have testified about the defendant having been insane at the time of the crime. I mean, what would the rule be to say that under those circumstances that it's not a reasonable choice for a lawyer who is presenting, obviously, strong mitigating evidence on, the 2 statutory mitigators and all that, but I mean, what would the rule be that we would say that a lawyer faced with that information from the experts had acted, below the level of reasonableness, which, as you know, is a pretty deferential test, I mean, how could we possibly say that that didn't rise to, that that's effectively the same as not even having had a lawyer?
Well, Your Honor, first, there were 17 or so experts that were consulted by trial counsel. However, not all of them were consulted for an insanity opinion. Not all of them were consulted for the mental health mitigators. The ones who were consulted and did testified to the existence of both statutory mental health mitigators. However, those statutory mitigators were demoted as a result of the sentencers finding that the drugs and alcohol factored into that.
Didn't the trial judge's order give, I can't remember which label, but it was significant weight to the mitigator, wasn't it?
The sentencer found that Mr. Covington suffered from bipolar disorder and gave that great weight. And with regard to the two statutory mitigators, those were given moderate weight. However, trial counsel was operating under a misunderstanding of the law in failing to present the testimony of Dr. Valerie McLean, who was ready and willing to opine that Mr. Covington was insane at the time of the offense.
Well, but the problem with that is you've got all these other people that said that it wasn't. So you kind of going down to a path where the refutation is going to come very aggressively and overwhelmingly. Am I wrong?
Your Honor, trial counsel should have at least attempted to present insanity at the time of the offense during the penalty phase.
But counsel, she testified, I believe, at the post-conviction, or it was there, that she was worried about opening the door, correct? I mean, there were 4 state experts that would have testified that he was not insane, and the trial judge had found them credible. So, I mean, what is the likelihood that, well, A, how is that ineffective when there was a clear strategic reason for not putting that on there? And then what would prejudice would have? It seems like it would have been perhaps prejudicial to present that when you had 4 experts willing to say that he wasn't insane.
Trial counsel had significant support from the mental health experts that did testify, again, with regard to the mental health mitigators. Additionally, Dr. Kropp had been on the fence about insanity leading up to the trial. Again, counsel was operating under a misunderstanding of the law with regard to the presentation of insanity, even though it could have, yes, opened the door to the state experts refuting what Dr. McLean stated, given her opinion on insanity. There was substantial other information regarding Mr. Covington's mental health, and the prejudice lies in the fact that the insanity, had it been presented by Dr. McLean, would have lent more support to finding greater weight on the statutory mental health mitigators. There can be no more compelling evidence than that someone is insane at the time of the offense. It's beyond just substantial impairment. Insanity reflects a complete absence of reason, the ability to reason. And so the prejudice lies in the fact that the sentencer did not hear that Mr. Covington was insane, and as a result, those 2 statutory mental health mitigators were demoted in weight. Also factoring into that were the drugs and alcohol, which do not negate insanity. In some cases, they can bolster it. When you're having that interaction between a mental illness to the extent that Mr. Covington was suffering, the lack of stabilization on the medications, the stressors, and the polysubstance abuse, insanity at the time of the offense would have been incredibly mitigating.
In light of the statute that says that voluntary intoxication is not a defense to a criminal act, do you have any cases that say that it is that the finder of fact can find someone to be insane while they are under the influence of substances that they've voluntarily taken?
Your Honor, I believe it is in Code v. State of Florida, 946 Southern 2nd, 988. There was evidence supporting a statutory mitigating circumstance that the defendant was unable to conform his conduct to the requirements of the law, and part of that involved the ingestion of drugs and alcohol.
But that's not a case where the person was found to be not criminally responsible for their acts. So it's not correct?
Correct, Your Honor. But there's nothing saying that it could not have been presented in the sentencing phase.
Are you suggesting that the evidence is such that no reasonable trier of fact could have found counsel's decision to be reasonable trial strategy?
Yes, Your Honor.
Okay.
I believe that evidence of insanity at the time of the offense, if it had been presented during the guilt phase, had a likelihood of success and would have resulted in a finding of not guilty by reason of mental insanity. Instead, counsel neglected to present that during the sentencing phase. So even though Mr. Covington waived all defenses to the guilt phase, he didn't waive the presentation of mitigation or this highly compelling information that he was insane at the time of the offense.
I think you're down to 3 minutes.
So, Your Honors, we are just asking that Mr. Covington's convictions and death sentences be vacated because these horrific facts, if nothing, lend support that these offenses were committed by a man who was seriously mentally disturbed to the extent of insanity. And that information should have been presented to his sentencer. It could have affected the outcome of weighing the aggravators against the mitigators. This is a highly aggravated case. However, it is not the least mitigated case. There is substantial mitigation present. The presentation of insanity at the time of the offense, along with presenting the alcohol and substance abuse as a separate mitigating factor itself, could have altered the weighing of the aggravators and mitigators. Mr. Covington is a member of a class of individuals who is seriously mentally ill. He has reduced culpability. His case is not one that involves a situation where there is no mitigation. Yes, it is truly horrific. However, Mr. Covington he accomplished substantial achievements when he was stabilized. It is not as though he committed horrific offenses his entire life. He suffered a massive psychotic break as the product of his serious mental illness, polydrug interaction, numerous neurodevelopmental complications, which also could have gotten greater weight had those been presented in more of a context. So there was substantial mitigation. Mr. Covington is more than the worst thing he's ever done. And we are asking that you vacate his conviction and sentence of death. And if there are no further questions, I will resolve.
Just to clarify, you've
Yes.
said twice now that you're asking us to vacate the conviction. You're just talking, but the remedy here would just be related to the sentence, right?
Yes, Your Honor, that's correct. And I will reserve the remainder of my time for rebuttal.
Good morning. May it please the court. My name is Marilyn Becue and I represent the state of Florida. I'd like to focus the court's attention on the procedural posture of this case. The issue before the court is whether counsel was ineffective in representing Mr. Covington. Mr. Covington had not just effective assistance of counsel, he had exemplary assistance of counsel. He was represented by a team of attorneys who among them had decades of criminal trial experience. Ms. James and Ms. Holt, who is the elected public defender of the 13th Judicial Circuit, had decades of capital litigation experience between them, all facets of capital litigation, trial litigation, appellate litigation, and post-conviction litigation. They were very clear-eyed about the challenges that Mr. Covington's case presented. He was accused of and admitted to the brutal murder of a mother and her 2 young children. He was found hiding in the closet where the dismembered and decapitated body of 2-year-old Heather Savannah was found, where the mutilated body of her brother, 7-year-old Zachary, was found, where the badly beaten and eviscerated body of their mother, Lisa, was found. Even the family dog didn't escape Mr. Covington's violence that day. Duke was found dead, bludgeoned to death in Heather Savannah's bedroom. Nonetheless, over the 6 years that they represented Mr. Covington prior to trial, they fully investigated his mental health issues. They discovered that he had a long-standing mental health disorder, bipolar disorder, that he had intermittent explosive disorder, and he suffered from polysubstance abuse disorders. They consulted with no less than 17 different experts, 7 of which testified at the penalty phase. Of those experts, only one, Dr. McLean, was willing to testify that Mr. Covington was insane at the time of the offense. Nonetheless, they were willing, despite the long odds, to go ahead with an affirmative defense of insanity during the guilt phase of the trial. As this court knows, shortly after the trial commenced, Mr. Covington became agitated. A recess was taken. He had conference with his attorneys. He spoke with his parents. The judge ordered a competency evaluation. The next day, Mr. Covington came in, pled guilty to all of the charges against him, and waived a penalty phase jury. The defense presented 7 of their 17 experts at the penalty phase. They all discussed Mr. Covington's long-standing bipolar disorder, his efforts to obtain help, and how the cocaine and alcohol abuse was a comorbidity of his bipolar disorder. And the sentencing court did find that he suffered from cocaine and alcohol abuse, and he gave that mitigator great weight. He combined it with the bipolar disorder and the intermittent explosive disorder. So he found those mitigators and gave them great weight. This was not a case where there was information that was later discovered during a post-conviction proceeding that was not presented at the penalty phase. The complaint seems to be that Dr. McLean just didn't utter the words insanity. Ms. James and Ms. Holt both testified, number one, they didn't think it was inappropriate to raise an affirmative defense of insanity during the penalty phase. Now, Mr. Covington isn't challenging his plea here, so he's not indicating that for some reason that they should have raised insanity for purposes of challenging his plea. But they did talk about all the same underlying mental health issues and disorders that Mr. Covington has suffered from his entire life to support the mental health mitigation. The judge did find both of those mitigators and gave them moderate weight. Well, let me step back there. He found the inability to conform his conduct to the law was impaired, but not substantially so because of his voluntary use of alcohol and cocaine.
It diminished.
Correct. It was diminished. Now, that was something they weren't going to be able to avoid because Mr. Covington did speak of it during his statement to the police, that how, particularly with alcohol, he knew he had a rage reaction. He also talked about throughout his entire life, his moods were kind of like an on and off switch. This was not, although this was a horrific act on Mr. Covington's part, it's not fair to say that he has no history of any kind of violence. The defense knew that he had a history of perpetrating abuse on his sister. He had some other instances with his ex-wife. None of this was focused on at the penalty phase as any kind of aggravator. Instead, it was discussed in relation to his various mental health issues. There was little that was not discussed about Mr. Covington. I agree, he has a history of mental disorders. He has bipolar disorder. He has intermittent explosive disorder. I can't disagree with the court's findings in that regard. They were determined by the court and they were given weight that the court felt was appropriate.
I'm sorry to interrupt you here, but is it fair to say that the testimony from defense counsel at the hearing reflected some maybe confusion or muddled thinking about sort of the difference between insanity as an affirmative defense versus just arguing insanity as a non-statutory mitigator?
I would not agree with that. I think they were very clear on the distinction between an affirmative defense of insanity and the mental health mitigation. They also knew that had Dr. McLean testified at the penalty phase that Mr. Covington was insane, the state would have cross-examined Dr. Rao and Dr. Kropp, both defense experts who were going to testify and did testify at the penalty phase, about their opinions that he was not insane. And of course, the state also had 2 experts lined up who were going to testify that he was not insane. There were other experts who had the same opinion that Mr. Covington wasn't insane. He was evaluated for competency. He was evaluated after he filed his notice of intent to rely on insanity by Dr. Mayer and Dr. Taylor. They both found that he was not insane. So the post-conviction court found that even if it were an available mitigating circumstance, it was a reasonable tactical decision for the defense to not take that extra step to go to the word insane and rely instead on the substantial mitigation that they did rely on, the mental health mitigation, because they knew that if they had opened that door that the state was going to walk right through it. Now, this case had been litigated for 6 years prior to this all commencing, so there weren't a lot of secrets between the state and the defense. Obviously, they had notified the defense they were going to pursue insanity. He was evaluated by state experts. Information was exchanged. So they were pretty aware of where the state would have went had they tried to introduce insanity. And frankly, it's potentially would have been objected to, but at this point, we don't know because it wasn't introduced at the penalty phase.
Can you maybe tell us mental illness was litigated in those
Sure. The defense did move the court to introduce mental health evidence short of insanity at the guilt phase. So in other words, a diminished capacity type of defense. That was litigated. That was denied. And they, excuse me, obviously did the notice of intent to rely on insanity. Depositions were taken. The state took the depositions of, I believe, I believe Dr. McLean, Dr. Kropp, Dr. Rao, possibly Dr. Saw, who was the doctor who evaluated Mr. Covington at the hospital, meaning the day after these events, and evaluated him for a Baker Act. I believe the state also took the deposition of, his name escapes me now, but the doctor who had treated Mr. Covington after the incident with his ex-wife and the cat mutilation incident that they had presented as evidence of his history of a longstanding mental health disorder. So it was fairly well litigated throughout the, it was obvious to both the state and the defense where we were going with this case because of the horrific nature of the facts. And Mr. Covington's ingestion of Tylenol, aspirin, and his Seroquel after the fact, that the issue was going to be what his mental status was when he committed these horrific crimes. The sentencing court issued a very lengthy and thoughtful order, understood the distinctions between the mental health disorders and the voluntary use of cocaine and alcohol. This was a very experienced judge who heard all of the evidence. He was not under any misconceptions about the significance of the mental health mitigation that was presented in this case. I don't recall, and I apologize if counsel discussed the antisocial personality disorder issue, but I just wanted to inform the court that this trial judge, as evidence of the fact that he understood the distinctions here, specifically noted in his sentencing order that he was not considering that as an aggravator. He understood that can't be used as an aggravator, and it was introduced merely to rebut the testimony of the bipolar disorder, which obviously he found existed and gave great weight. I would urge this court to affirm the post-conviction court's order denying post-conviction relief in this case. Unless the court has any other questions, I'll relinquish the podium. Thank you.
Counsel, rebuttal?
Good morning. David Hendry for rebuttal. Insanity is different. This case is very different. I've been arguing before this court for about 20 years now. This is my very first insanity case. It doesn't happen all the time in these cases. Mr. Covington is mad. He is insane. It's elementary that when a man is insane at the time of the offense, you present evidence that he is insane at the time of the offense. There was no waiver here, and that's the crux issue in this case, is did Mr. Covington waive insanity at the time of the offense at the penalty phase? And if you look at that penalty phase, if you look at that plea form, which was exhibit number 20, state's exhibit, it's a very long plea form, and there is absolutely no waiver of insanity at the time of the offense at the penalty phase. So it's not knowing or intelligent, at the very least. It is elementary. As a criminal defense attorney, a capital defense attorney who's very experienced, you have to present insanity at the time of the offense, because it's not just the two statutory mental health mitigators. It goes way beyond that. It's not that he wasn't playing with a full deck. He didn't have a deck.
Well, but counsel, I mean, I understand your position on this, but there's still the problem of all these experts that say he was not insane. I mean, do you dispute? You shake your head. Do you dispute that the numerous experts said that he was not insane at the time of the offense?
You start with your best foot forward. Dr. Valley McClain.
I asked you a question.
Okay.
Do you dispute that?
3-0. Post-conviction, 3-0. It was unrebutted that he was insane at the time of the offense. We met our burden. We presented Dr. Cunningham, we presented Dr. McClain and Dr. Wood with a PET scan that showed that this man, he has organic brain damage.
What was the count at the time that counsel was making the decision whether to characterize this as insanity, which is that's the relevant point in time, not the experts that you had at the post-conviction hearing. What was the count?
That's a red herring.
No, it isn't. What was the count?
I didn't try this case, but I will tell you this. They had at least one expert who said insane at the time of the offense. And it is disingenuous to say we were going to go to the guilt phase and present insanity at the time of the offense, and then at the penalty phase to say it's not really genuine. We only have one expert. Dr. McClain can't be believed.
So you don't know the count?
The count of...
At the time that counsel was making the decision?
I know that Dr. McClain said insane at the time of the offense. This case was very perplexing because there's absolutely no discussion whatsoever about insanity at the time of the offense in this court's direct appeal opinion. So we had to dig and dig and dig to find that opinion that he was insane at the time of the offense. And again, you start with...
I have to say, I'm kind of disappointed with your candor at this point. I mean, we've talked about it now in the OA. Are you telling me that you don't know what the count was or ballpark? You know that there were other experts who had been consulted at the time that counsel was making this decision.
I know that Dr. McClain opined insane at the time of the offense. And I know that there wasn't a lot of go-between between defense counsel and these mental health experts as to you have to ask your mental health experts, was he insane at the time of the offense? And going to Justice Lawson's question about the voluntary intoxication, 3.6, there's nothing in the jury instructions that really that say that if you ingest crack cocaine and alcohol, that this negates the insanity defense. Crack cocaine and alcohol would only accelerate insanity at the time of the offense. And, you know, I'm trying to be candid here. All I can say is that we had 3 experts, unrebutted, that said insane at the time of the offense, and opened the door as a criminal defense attorney, it's your job to try to open the door. Here's the question that this court has to ask, okay? Had defense counsel tried to present insanity at the time of the offense, and had the state objected to this evidence, and had the court prohibited this evidence, would this court then reverse that decision? Because under Hitchcock, Eddings, and Lockett, any circumstance of the offense is presentable, is admissible at a penalty phase.
Counsel, you've exhausted your time. I'll give you another 30 seconds to sum up.
Thank you. The very relevant cases here are Hardwick from the 11th Circuit and Kimmelman from the United States Supreme Court, which we cited, which basically say this: defense counsel was operating in this case under a mistake of law. They said it was inappropriate to present insanity at the time of the offense. That is wrong. Because that is wrong, this cannot be a reasonable strategic decision. This is elementary. You have to present insanity at the time of the offense in a capital case when a man's life is at stake. Thank you very much.
Thank you, counsel. We thank you all for your arguments in this case today. The next case on today's docket will be heard remotely. So that concludes this session of court.
All rise.